Ms. Sotomayor?
Am I correct to say that you say the only order a district court can give overnight is basically the ABA rule? A lawyer can only be prohibited from telling the defendant to give false testimony, correct? That's your definition.
Well, I mean, I would say.
Counsel, just answer yes or no.
Well, okay, mostly yes.
Okay. So assume, please, and don't fight me, that I think that Texas's position is more nuanced. And I accept that improper coaching that could be prohibited included walking through potential questions and answers, telling a defendant to use one word and not another word, what generally is thought of coaching. But Texas, and I think Justice Kagan defined their position, they can discuss incidental effects of testimony, and that would include, and pay attention to the list, plea bargaining, including telling a defendant that they did lousy and they should take the plea, perjury, you lied and you shouldn't, excluded evidence, the one that you were worried about, other witnesses and where they might be located, contact information. What else? What is missing from that list? Assuming the first bucket.
Yeah. So
you can't coach, you can't give questions and answers, you can't tell them to use a particular word or change a word, even if it's not perjury.
Okay.
Assume all of that. What's missing from that list? What other thing is missing?
Well, that list covers many of the most important things.
I just said.
But what it doesn't include is what you specifically excluded at the start, which is going over questions and answers.
All right. So if I say no to that, but say yes to the incidental effect, there's no other topic that you can imagine?
You know, off the top of my head, I'm sure there are others. I mean, a defendant and counsel have a million things.
Wouldn't the definition that Texas provides, which is the incidental effects of testimony, is okay?
That's no line at all. How is anyone
Assuming
supposed to?
I believe there is the workability issue, there's no other topic you can think of.
Well, if you gave me a little time, I could probably think of more, because there's an infinite number of things.
Now, going back to Justice Thomas's question, there's no facts in this record that would suggest that the defendant wanted to talk about plea bargaining, or the counsel wanted to talk about a missing witness, wanted to talk about perjury. There's nothing in this record to suggest any of that, correct?
That's correct, but the reason is that defense counsel understood the court to be barring all discussion of testimony, period, and the court confirmed that.
Counsel said, Judge, I understand what you're saying. I won't manage the testimony.
No, there's more. So the colloquy here is at pages 4 and 5 of the blue brief, right? So the court says, what you can't discuss is, this is the second to last paragraph on page 4, the court says the thing that you can't discuss is, at the very start of that paragraph, his testimony. And if you look at the top of page 5, defense counsel says, we aren't going to talk to him about the facts that he testified about. Court says, all right, fair enough, right? So the reason why there's
We can read the transcript.
Okay.
Thank you, counsel.
Okay.